Hello, and I am Bob Mata, and this is Defense Diaries. I am your host, and I am joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
So, what are we getting into today?
Some Kelsey Fitzsimmons.
All right, all right. If you guys aren't familiar, we had a lot of people reach out to us and are like, "Hey, y'all need to take a look at this case." It's another Commonwealth of Massachusetts case. It's another one that sounds insane to me. And sad, and there's like a lot going on with it. But if you don't know anything about the Kelsey Fitzsimmons case, Kelsey was an off-duty North Andover police officer who was shot by a fellow officer who I believe was her partner. While in the process of that officer, her former partner, trying to serve her with a restraining order. Where it gets strange is that ultimately Kelsey ends up getting shot, which we'll get into throughout the live. But kind of the 30,000 foot view of this case to me is that this is a case that delves into heavily into mental health, law enforcement, domestic issues, and how our legal system is currently situated to handle these types of cases and these types of crises. So I think ultimately what we want to do first, babe, right, is probably walk through some of the background.
Yeah, I think you could start with the what got all of this started. And I wanted to just put out there that we wanted to play the audio from the bail
Yeah,
revocation
and Mike
hearing.
Mike got back to me, so we're good to go. So
Oh,
you could
okay.
throw out the young jerk stuff.
Oh, all right, good.
So yeah, we'll start with that. But before we get to that, why don't like to me, the first thing that when we were and it seems like it's kind of hard to get documents in this case. So it's really taken a village. We've reached out to a lot of our friends, fellow creators, including obviously Mike Crawford of Young Jerks, who is awesome and we love him. We obviously hit up Melanie
She sent
because we
us
know
what
that
she
they've
sent.
been covering it and they've given us what they have. It's been challenging, but
Tracy's hunted some stuff down.
Tracy, as always, hunts stuff down. She's the best in the business. Um, but what I wanted to see, what really was the most important thing for me to see from the front end is I wanted to see the affidavit from Kelsey's former fiance, um, in terms of the allegations that he was making against her when he filed the motion that they were trying to serve.
So
Okay.
just as
And
background, Kelsey Fitzsimmons was an officer in Andover Police. Um, and she was shot by her colleague, one of her colleagues.
yeah, yep. I already gone through that portion of
Oh,
it.
sorry. I think I was still looking, trying to figure out a place to get that audio.
All right, so I've had to kind of screen grab these. So this is the affidavit that was attached to the petition for the protection from abuse uh, petition that was filed. All right. So anytime that you're filing that here in Illinois, you can go in without the other party being there, and you could basically tell your story to the judge. If the judge thinks that you meet the criteria that it's required in order for that judge to put a temporary order in place.
And it's temporary because it's ex parte, meaning the other side doesn't have an opportunity to be heard. So
Correct.
they've gotta they do these on an emergency basis, and they start out as temporary. So
Right.
Bob's gonna read you some of the statements that the, Kelsey Fitzsimmons fiance alleged in
She
his
did it. She
affidavit.
did it again. She did it again. We thought we got the Fitzpatricks out, but you still did it. Do you know a Fitzpatrick?
I don't know, it's just a nice Irish name.
It's true. It is a nice Irish name. All right. So this is the way the affidavit reads. And again, this was handwritten. It was drafted up by Kelsey's firefighter, at that point, fiance, and the father of their child. So Kelsey Fitzsimmons is a danger to myself and our son, along with herself. On Saturday night, June 28th, Kelsey struck me with a closed fist 3 times to my face. I was scared that she would not stop. Now, my brother and sister heard, uh, sorry, this is really heard noises, and then they knocked at the door. So I was able to open
Abel.
the door, and and then there's a portion of it which was scratched out in this handwritten narrative where he had said immediately she said that she didn't do anything. I feared, and that's all scratched out. But the way that it reads fluidly, and then it says, and then she grabbed my arm and ripped me. Um, let's see. This is not optimal.
Ripped me back into the room. My brother and sister came in, and she said she didn't do anything. I feared for my life.
So I left with a friend to stay at a hotel. Family and her closest friends reported that even after I left, that she uh,
Physically hit them.
physically hit them. Yeah, if you have a clearer copy, read it because this
I don't
sucks.
know.
Because
That
I'm
next
piecing it
word is
together.
I can't make out at all. She physically hit them to something.
Wait, let me see where you're at. She physically hit them to try and get to me. Her friends called the Bethel police in Maine. I can't make out the name of that. It looks like Metherin. Like, do you guys know in chat? This is
A
handwritten. I
certain
can't
place
see.
in Maine, right?
Well, the
And
first place was in Maine. The second place was in Mass, and then the Andover, the North Andover police, also in Massachusetts, because they thought that she might try to hurt herself, the baby, or me. Um, Kelsey decided, uh,
at 2 a.m.
yeah, God, this sucks.
while
I hate.
heavily I got it, while heavily intoxicated and fighting her friends, that she would, hmm, leave to get the baby. Her
Yeah, that she
parents
would leave. Yeah,
took
leave to get the baby.
parents took our son from my parents in the middle of the night, saying they didn't c
Care what manic state she was in. That they were taking the baby to her today, and then Kelsey, um, threatening to take the baby.
is threatening.
Yes. Oh, is threatening to take the baby far, far away for a very long time. This is how She has spoken about killing herself in the past. I fear that she will unalive the baby at any moment. She punched her stomach repeatedly while pregnant, saying that she would unalive herself and the baby. I fear that if she doesn't have me, she will unalive the baby because she has said that she has nothing besides me. So, I mean, obviously, that's pretty heavy shit.
Right. And now I've got her lawyer's statement to get some of the other side of the facts here. Whoops. So from the law office of Timothy Bradle, and that was Aiden, or is Aiden Lawyers as well, aka Turtle Boy. To all media outlets, please direct all inquiries. Okay, so reason North Andover police officer Kelsey Fitzsimmons releases statement to set the record straight. It's time to end the quote PR war on North Andover police officer Kelsey Fitzsimmons. As Kelsey recovers from her life-threatening injuries, she cannot sit idle any longer. Actually, before we get to that, um, maybe we should give a little bit more background of what happened. So, um, whoops. All right, this is messing with me. I'm getting that. Oh, I know why. All right, so I'm going to just pull some of this from a news article. We'll share this. Are you seeing this screen now?
Uh,
Fiance of wounded North Andover officer feared.
yes.
Okay. So they talk about how the details are emerging, stuff that Bob just cited. Fitzsimmons, 28, had been with the North Andover Police Department since last spring. She was on administrative leave Monday when 3 other NAPD officers arrived at her home on Phillipsbrook Road to serve the restraining order. As one of the on-duty officers was escorting her, an armed conflict, that's what they called it, broke out. Essex District Attorney Paul Tucker said earlier this week, one of the officers fired their weapon, striking Fitzsimmons. She was flown to Boston Area Hospital and was in stable condition as of Tuesday morning. In his application for the restraining order, um, the fiance noted that she is an officer with a license to carry. He, quote, expressed concerns regarding Fitzsimmons' reaction to being served. He described how Fitzsimmons struck him. So we talked about that already, how the parents took the baby, what his fears were. So authorities have not said whether Fitzsimmons was armed at the time of the confrontation, which we now know they claim that she was. She was ordered to surrender any weapons to authorities in the restraining order. Fitzsimmons was denied her firearm identification card earlier this year, according to records in the Lawrence District Court. She sought relief in an attempt to have her card reinstated, but she withdrew that petition last week. Records obtained from the Boston Globe show that she was involuntarily committed to Lowell General Hospital for 12 hours in March to be treated for postpartum depression. She surrendered her department-issued firearms, at least one privately owned weapon. She had met with a therapist and was being seen by a psychiatrist. She was cleared to return to work June 18th, according to the Globe. It's unclear if her weapons were returned to her. So what we also know, and that's not stated in here, is, you know what? It'll get into some more of the details in this, going back to this press release from Bradle's office. Again, it's time to end the PR war on North Andover police officer Kelsey Fitzsimmons. As Kelsey recovers from her life-threatening injuries, she cannot sit idle any longer. In our first press release, we were honored to speak for Kelsey when she was fighting for her life and could not speak for herself. As stated, we would have preferred to address the facts in a manner in court, but Kelsey believes it is imperative that since she has been battered with leaks from negative and false allegations. She speaks out now to set the record straight. You want to read her actual statement there, babe? Want me to just
Yeah. Can you pull it? Okay, so this is from Kelsey directly. My name is Kelsey Fitzsimmons, and as I recover in my hospital bed, I am ready to speak about the incident that took place on June 30th of 2025 in my own home, where I almost lost my life. I was diagnosed with postpartum depression in March of 2025, approximately 3 weeks after giving birth to my beautiful baby boy. I have actively been in treatment since the day of my diagnosis and was eager to heal and feel like myself again. Unfortunately, healing a sickness does not happen overnight. However, what can happen overnight is my life turning upside down into, scroll up, babe,
Oh, sorry.
something so horrible that my mind wouldn't even be able to imagine if it weren't my current reality. Someone who I thought understood my diagnosis, loved me and in sickness and in health, and was in my corner for the journey of my active treatment to get better, turned their back on me. Said person is now legally bullying me to get what they want, slandering my character and using my diagnosis against me to make me seem like I am a monster. There are more false allegations than I can even comment on. The deep love I have for my baby boy sustains me and keeps me strong. I haven't spent more than a night away from him since I delivered him, and I adore every moment I spend with him. He's my best friend, my miracle, my little man, my sweet boy, and most importantly, a giant piece of my heart. Right now, that piece of my heart is missing when I need it most. I am 5 months postpartum without my baby boy who needs me as much as I need him. I would never put that angel of a child in harm's way. My job as his mama is to protect him. And that is what I have always done and will continue to do for the rest of my life. Becoming a mother has always been my dream, and I never made any threats towards my baby. That allegation specifically makes me sick to my stomach. I was alone with my baby day in and day out for months, caring for him as my fiance frequently worked 24 to 48-hour shifts, but conveniently, there were never any concerns up until now. On June 30th of 2025, I received a phone call from my fiance to meet him at the park to go for a walk with our baby boy together. After almost 3 hours of waiting for him at the park and no communication from him, I went home very confused as he never showed up. About an hour later, I was sitting on my couch feeding my baby boy when I got a knock on the front door. Very confused to see three of my colleagues. I open the door and I am told the following: your fiance has filed a restraining order against you. He will be taking your son away with no contact allowed. Your firearms license that was just returned is gone again. And oh, yeah, that career you worked so hard for and love, uh, and that you were just clear to return to, that will be taken away too. Following this interaction, I packed bags containing baby food, clothes, diapers, toys, etc., for my son to be taken away from me. I passed my son off to a fellow officer and I went into my bedroom. In that horrible moment, I didn't want to live after my whole world was turned upside down in the matter of a 10-second conversation due to somebody alleging horrible, untrue things. We have a broken legal system where someone can walk into a courthouse, write anything that self serves them on an affidavit, and as a result, a brand new mother suffering with postpartum depression gets her baby taken away. We are calling on the legislature and the governor to reform this abomination of a statute where the first person to get to court and fill out a form can take a mother's newborn baby away from her if they can sneak in front of a judge without the mother's notice or opportunity to be heard. If there is an immediate issue, someone can call 911. The courts are not equipped for proper on the spot decision making in this context without hearing from both sides.
Let me just chime in here. I just want to say, I think based on the allegations that he wrote, that they should not have granted an emergency and instead sent out, maybe sent DCFS, which is here the Department of Children and Family Services, to do a home visit, to check, to to see if they think that the child's at risk. I mean, it wasn't even what he wrote wasn't so, evident that she actually posed a danger to her child. I think to warrant that type of emergency, you know, that
Yeah.
type of an emergency intervention, as opposed to, look, someone has postpartum depression. They make these allegations that a child's at risk. They have to do something quickly just in case. But I think that there were things short of just saying rip the child from the mother.
Yeah, and just so you have an understanding, when you go in on, like, we call them temporary restraining orders here, which can then blossom into what they call a plenary order of protection, which is permanent. Typically, it's a 2-year period of time in which that order is in place. But when you go in, say for instance, he could have gone in, if true, or if not true, again, she's got a good point that he can go in and say whatever the hell he wants because it's unchecked by what she would say happened on that particular situation. But he's going in for protection of himself in terms of him alleging that she punched him in the face 3 times. That kind of contact, especially if he's able to show marks, would be pretty effective in terms of getting a judge to issue a temporary restraining order. Now, when he decides to try to include his baby as a protected party, that creates another burden in and of itself in terms of that judge saying, okay, well, I'm going to have you as a protected party. I'm not willing to have the child be listed as a protected party as well because you haven't shown me enough. And based on what Allie was just saying, what I read seemed like a lot of speculation.
Right, he says the words, "I fear if she does not have me, she will kill the baby because she has nothing besides me, is worth living for."
Yeah, and
What
the
but
other
that's just words.
them's just words. The only thing that even came close to,
"I'm gonna take the
I
baby
think,
far,
reaching
far
that birth,
away."
well, no, it wasn't the taking the baby far, far away. That's part of it, but that he claims that she was punching herself in the stomach while she was pregnant with the baby. So that would be the only thing that I
But
think
that
would,
was not that wouldn't pose an emergency to the child, you know, right there. And again, threatening to take the baby far, far away is definitely an issue that comes up
for
in
sure.
a but you have, again, this is a police officer. They I think that the judge could have ordered to have someone do you know, a home inspection and see what an independent person thinks as far as a
Yeah,
uh
because that's the problem with these things, and I agree wholeheartedly with the concept. It's the same way here in Illinois, where you go in ex parte. Again, that just means that the other party's not there. But essentially, whatever that person says is taken as fact. It's not challenged at that hearing because they typically try to get you in front of a judge immediately upon filing. So you're typically within a judge within an hour. You typically will stay at the courthouse. They'll say, "All right, we've got a judge for you." You'll go into whatever judge has availability. You'll lay out your facts, and then that judge decides whether or not they're going to issue the temporary restraining order.
and it's supposed to have a quick turnaround. It's an emergency restraining order. You have to say, establish that there is an emergency and that the physical safety or risk of kidnapping, I guess, would fall in as well, is imminent. And then they, very shortly thereafter, they have the chance to come in and actually fight it, which didn't happen here because at the time of serving the Kelsey
Well,
Fitzsimmons, with the fact that a temporary restraining order had been issued, all of this transpired.
and I think what kind of begs the bigger question, whatever that was going on in their relationship, it seems like it was faltering, and again, I don't know her or her fiance from a hole in the ground. I'm not a party to what went in within the 4 walls of their house or whatever whatever was going on, I don't know. But when I look at it objectively and I look at his allegations wherein he's claiming that she punched him 3 times in the face that night, where is the 911 call? Why wasn't law enforcement called at that point in time? Because and we've seen it all the time in these types of situations wherein it's either a divorce case and somebody wants to get possession of the property, and or they want to get the spouse out because the other party has the kids and they want to be able to live in the property. We've seen these statutes and in particular be used as swords as opposed to the shields that they're supposed to be. These statutes were created really to protect women because forever in this country, women were being abused, beaten, whether it be emotionally abused, psychologically abused, financially abused, all of the different abuse that was going on. And women had no way and no opportunity to be able to get in front of a judge and say, Your Honor, this is what's going on in my life. So that's what the birth of these by state legislatures, these statutes started coming out in order to give the women a shield to protect themselves that didn't exist in the past. So, I mean, to me, it's problematic that he didn't call 911 on the night that he's alleging he was punched multiple times in the face. And it smells a lot like it was a move to get custody of the kid. And this is a way to do it. This is the quickest way to get your baby or your child out of the hands of one parent and into your hands, is to go in and file one of these. And that's just facts. Because if you're going through your typical custody or allocation of parenting time type situation, that can take forever. And it does take forever. And usually there's not any kind of switching of hands. If there's temporary orders that are prepared and negotiated between the parties during the interim, that's fine. This is a situation wherein you go in and file this, you get the child listed as a protected party. They are literally taking the baby out of her hands and bringing it to her fiance. So that has to ring as a possibility of what's going on here. All right. So where did I leave off?
In the paragraph that's showing.
Okay. So so we're going back to Kelsey's own statement, which was included in Bradel's press release. So as a police officer, I'm trained to know what to do if I encounter a suicidal individual who is only displaying a threat to themselves. I certainly was not trained to shoot a suicidal person in the chest, but here I am today, 2 surgeries later, bedridden, and trying really hard to heal from these significant injuries. I am facing felony charges for a half-hearted attempt to take my own life. Let me say that again. I am in trouble and have a gunshot wound to my chest because in that awful, isolated moment, I no longer have the will to live. I never pointed and this is in bold for emphasis, I never pointed my firearm at the officer. That officer was not just a colleague, he was my friend. That officer and I experienced a very difficult and sad call for service together last summer. That call for service that day was a true tragedy and caused this officer and I to build a friendship due to experiencing it together. We entered the home and walked into something no human being should ever see, a murder-suicide scene with a mother and her infant. As a rookie, in parenthetic,
Whoops, sorry.
oh no, as a rookie police officer, this was devastating to me. At the time, I was 20 weeks pregnant. The officer that shot me experienced this call with me. To this day, his support during that hard time is something I'm still grateful for, regardless of this recent incident that occurred. This traumatic suicide call was the catalyst for my mental health complications. As a police officer myself, I would never even think to intentionally hurt another police officer. I see everyone in uniform as my brothers and sisters. I especially would never hurt my friend who has a loving wife and children. I just would never. My firearm was never pointed in any direction other than my temple. When I pulled the trigger, my gun did not fire. However, I immediately got shot in the chest by my colleague and my friend. I am extremely grateful for 2 things. One, that God protected me from my attempt of taking my own life. and protected me by millimeters from dying from that gunshot wound in my chest. I will survive and thrive. I know I need to be on this earth for many reasons, but most importantly, my beautiful son. This is my covenant with God and my son. I would also like to note that from the beginning, I acknowledged my diagnosis of postpartum depression and immediately sought help from medical professionals. I was failed by so many. The narratives that have been released by the NAPD is vague and non-committal for a reason. If body cameras were worn by my department, I would not be in the position where I am wrongfully accused of pointing my gun at this officer. I know the truth will prevail. Kelsey Simmons.
So I'm just gonna say, um, based on like just that, this is my assumption. It may not be popular. I don't know what everyone's been, all the chat that's been around this, but I think that the other officer just, a gun is in play and his training says, shoot, and that he did not see her point the gun at him, and that he maybe either recreated the image in his head or was
Are you
like
saying he
pulling
has a false memory?
he either has a false memory or he's just
Wow.
trying to cover his ass. Like, "Oh shit, maybe I shouldn't have shot." But in my head, even if he said the truth that she had a gun, she didn't listen to warnings to remove it from her own temple, and he shot, that is fine because somebody could just as easily be pointing here and then go there. I don't think it would have been that he would have got himself in hot water. I think he panicked, he overreacted. It's exactly what Shannon M is saying right here. Um, and then just kind of either recreated the story in his own mind so it made sense to him or he was covering his own ass. I just don't think like that, and I don't know if it's a conspiracy theory that's out there, like that they went in with the intent to do any harm or that they were, I don't know. That's just kind of the way that I see it. Um,
Yeah, and I mean, if you're being honest about a situation like that from either side, from the colleague friend side or from Kelsey's side, like we're talking about a matter of seconds that this stuff goes down. You know what I mean? So in terms of whatever he decides that he needs to say happened in the interim, while they're in the process, okay, officer down, officers fired a shot, and you've got this period of time while other officers are going to be responding, and you've got emergency medical personnel coming to the scene. Like he's got time to think, right? So, whatever really went down, it's a crying shame that there isn't body worn cam. I don't know what the budget is for the North Andover Police Department, but in this day and age,
it should be mandatory
it
in
should
every
be
department,
mandatory. You've got to carve out whatever it takes. I mean, if she's
especially
right,
in light of just police corruption. I mean, to
right,
protect the police, to convict the bad guys, but also to make sure things went down the way the police say. And I think it's possible here that the officer that did the shooting trying to make sense in his own mind it's possible he does actually believe that that's what happened because he's trying to justify like his own conduct, like, well, she was pointing a gun at me, like whether that's, I believe her that that's not what happened, that she was trying to take her own life. Um, and I don't and to me, it could be either way, that he's trying to cover his own ass, so kinda shifted the story, or the way the mind works, and you're trying to make sense of it, that she pointed the gun at me, like, that's what he thinks he saw because he saw it as the next possible thing that could have happened. And Josh H says if an armed conflict actually occurred, there's no way the police would only fire one shot. They would have emptied the entire magazine. Now, that might be true in a typical situation where the person's not your friend on the other end of this. And that's sort of the whole fact that these two were close is what's um kind of guiding my kind of opinion on this. So, let's
Well,
talk
why
about
doesn't he shoot her in the leg? Like, why does he bury one in her chest? She's
that's what they're
clearly not
trained to
gonna.
do. You shoot
But,
someone in the leg, that doesn't stop them from pointing a gun at you.
I understand
Maybe
that,
shoot
but
them in the hand, the
I
arm.
understand that, but you just said because she was her friend that's why he didn't empty the magazine. So by that same logic, why didn't he just disable her by, like, say, shooting her in the leg?
If he
Why is he
thought
putting one in the chest?
if he thought she was unhinged, I'm just saying ifs now, devil's advocate here. Um, and that she might very if she's desperate enough to shoot herself and it doesn't work, she's desperate enough to try and go out by suicide by cop, by pointing the gun at him and possibly even firing. So, it's a split second decision. It's like he just that's the way that he reacted in that split second. Um, so let's talk about what happens, afterwards. This is like such a troubling, you know, case for me just because as Bob and I were talking off air earlier, it's just like mental health is not taken serious enough and they're treating this woman as a um she was intentionally trying to kill this person. Even if you accept what he was saying as true, as opposed to someone in the midst of a mental health crisis who has dedicated their life and is always, to helping the public and helping people and has never, done anything to risk anyone's life before, you know, but they had to fight to even get her out on bond, on bail, and the state tried to say no, she needs to be held without, and the judge said no, we're going to craft this um, her conditions of bond so that she can be released, one of which was to wear a scram device which detects alcohol. Now, this case didn't involve, at least as far as I know and have been able to see thus far, involve an allegation that at the time this went down, she was intoxicated. But it does involve allegations that she has been abusing alcohol and acts erratically when she is intoxicated. So the judge put this detection of alcohol condition as a condition of bond. Now, Bob and I are used to scram bracelets. You put them on your ankle. They detect alcohol through perspiration, through your skin. But the ones that they use out there, you have to breathe into it physically if you're familiar with the way the systems work when you get a DUI and they put the system on your car so that you've got to breathe into it and they can they can confirm that there's no alcohol in your breath and it's supposed to be random. But the defense goes in and they motion to get that
Wait, can I
um
jump in before you go
yes.
there? Because I think it's relevant, and it matters that originally when they charged her, they presented 2 different charges to the grand jury. First was, armed assault with an intent to murder and assault with a deadly weapon. So the grand jury rejected the armed assault charge and indicted her on the lesser charge. So, which I think is significant. I mean, they didn't think that there was enough there to charge her with the intent to murder.
But the
Well,
prosecution was still the fact that they even tried to charge it.
that's what
The
they
fact
do. They overcharge. I mean, come on. Like we live in this world. Like we know. Like that is they always are overcharging.
And I
You
wonder
know,
if the prosecution and the judge are trying to be overly harsh so it doesn't appear they are giving an officer preferential treatment. If they are going over the edge to the other side just to show we're going to punish a cop the same as we would punish anyone else. Do you think that there's some of that in play here with the overcharging, with the way the judge is treating her?
I mean, potentially, yeah. I mean, this judge, and we're going to get to her. and we're going to listen to the hearing where Bradel was trying to argue it. But yeah, I mean, how can I discount that?
And
Uh,
Under Your Scars says funding approved a year ago. I had heard. What was that funding
I'm
for?
assuming that's for body worn cams.
Thank you. Yes, you did say that. 3 cops go, only 1 inside with her, no child services attending, alcohol testing, why? Judge replies, no alternative way off, bull. That judge is disgusting. And we're gonna about to get into all of that. Creed says, interesting the victim blaming regarding the dad. Would Bob say, why not call 911 if the genders are switched? Her act to
Yes.
offer selves gives dad credibility. I don't know why everyone believes her at face value. I'm not saying to believe her at face value at all. Everything that the father said very, very well may be true. And I would agree, Creed does have a point. Well, why not call 911 when the gender roles are switched? We do talk about reasons why a spouse might not call 911. So, you know, it's food for thought, but your point is taken on that aspect of
Well,
herself.
no, I mean, for me, you don't have to answer. For me, yeah, like the gender for me, had absolutely no impact on whether or not wondering why in a situation when there's custody. And again, that's why I laid the framework when you see these situations wherein you have one party running in to get a protective order. And that's not to say that it's not legitimate, but when you have a case that, because when we're attacking these in court, like if we've been retained to fight a temporary restraining order and I get this fact pattern, you can bet your ass that the first question I'm asking that person, in this case, the accuser slash the victim, why didn't you call 911 when you were punched in the face? I don't give a shit whether it's the man or the woman. Like, I mean, because that's what you're supposed to do. If you've been assaulted, why didn't you call 911? Because at this point, it's he said, she said. And if you had the ability to be able to make a record in terms of a police record by calling 911, I would ask either party. So the
Right.
gender thing
Well,
for me has nothing to do with it.
but Bob, asking the question in court because it helps your point, doesn't change the fact that there are many reasons an abused spouse isn't going to call the police because they don't want further abuse, because they don't have anywhere to go, because they're afraid. I mean, that's just the point that Creed's making, and I think it's obviously a valid point because we talk about it often when they try to say it in the reverse. When you've got um, a wife or a woman using battered spouse syndrome, and they're like, "Oh, there's no calls to the police, there's no outcries, there's no claims." But that doesn't mean in a court of law you're not going to, to ask it to ask it anyway. Um,
I mean, my
and then
general proposition as to that has always been, specifically with domestics, if this was like some hand fighting and pushing, I'm always of the mindset like you're talking about two grown adults here. If it didn't get to the point where people are punching each other in the face and doing heavy damage, then that you do want to think long and hard about involving the police in your life because it turns into a whole thing. We see it all especially
when there's
if it's
children.
if it's like an argument that just got heated and one of the parties pushed the other or grabbed their phone out of the other's hand and the other is called the cops come, they're arresting somebody. Like they're not walking out of that house in those types of situations without arresting somebody. In this particular case, he's alleging that she punched him 3 times in the face and that was screaming so much and was so unhinged that his siblings or his whoever it was, his brother and his sister, came and knocked on the door. So I don't know. Like, I mean, there could have been a conversation going on in terms of why he didn't call police, but I'm just saying, in my estimation, I'm calling. I'm calling him out on that, whether or not there's a good rationale behind it or not, because he saw fit to bring it up in terms of getting, and it was the first thing that he brought up in his allegations to get the TRO. So, I mean, you'd have to attack it from an attorney's perspective if you're trying to fight the TRO.
Right. And Tony says what really bothers me is that this order was issued without any evidence that she harmed the baby. And we did talk about that, and Bob did point out there was the allegation that when she was pregnant, she was punching herself in the stomach and said, "I'm gonna what was it? Kill myself and kill the baby." Where was it? Where was it? Um
It was towards the end of it where
yeah,
he essentially said that when she was pregnant that she was punching herself in the stomach.
right. Um right, and there was some kind of corresponding statement like uh about killing herself and the baby. But again, as we pointed out, that was something not an allegation that was current. And there's oftentimes many reasons that the courts they that this is the only way that we have come up with a way to protect people from abuse. They come in, they say it, the words that they are saying, if enough, warrant the emergency order of protection. And then you've got shortly thereafter, you know, it's going to get heard from both sides in court and get worked out. So, but again, we just didn't think that these allegations were enough to establish that the child was in imminent harm at that point in time, that she had done anything to threaten the life and safety of the child to warrant taking the child away as opposed to
Yeah, because of
uh,
the fact of the matter is, right, if they come in and they're serving a protective order as to just the fiance, she's probably not in that state of mind. It's when he adds the child as a protective party and it comes to the realization, she comes to the realization that they're now stripping her of her child. That's what exacerbates this entire situation. If it was just him, she might have been upset, but it should have been like, all right, well, fuck it, I'll fight it in court. When it turns into now we're taking your baby away from you, it's an entirely different situation. Wildlight Arts says I was chased with a knife across a home 2 towns over. Then an abuse order was slapped on me. Does it does happen here in Mass, Bob? It really does. That's exactly what I was saying. I wasn't saying the opposite of that. When you have an ex parte, meaning that the other party is not given notice and they're not there to give their side of things, it happens all the time. And what I'm trying to say in that situation, Wild Light, I would be making that argument that the abuser was the one using it as a sword, not a shield. That's why I went through that whole thing talking about that these statutes were created for women to protect them, not to be used as swords in divorces and in custody fights, which is what's happening a lot from both sides. I mean, we see it from both sides all the time, and and they're hard fought. Like these things are really really difficult to kind of figure out what happened because they're almost always he said she said, and you're not going to have much evidence. That's why, again, harkening back to the concept of if this kind of abuse is going on and for whatever reason you forego communicating to law enforcement and dragging them into the situation, which does create a whole nother thing. You then have a DV charge you got to deal with in a criminal court, and it haunts you and it follows you, and it's a big deal. So there are reasons why where cooler heads prevail, that maybe cops don't get called the situation. But when it continues down the road and you have no record of it, it is problematic in terms of trying to get those orders put into place where you've got somebody who's adamantly in there testifying, look, this person has been abusing me for months and there's no record of it. And it's an unfortunate circumstance because I've been on the victim side many, many times wherein, that order gets overruled and the judge won't issue it because there's simply not enough evidence there other than the testimony. Because if you've got a person that's somewhat of a sociopath that's able to get on the stand and just lie and just make up any kind of story, and for all intents and purposes that person looks like a stand-up citizen, you've got a very very tall mountain to climb. So this thing is like this trial, the way it's going to play out is going to be really, really interesting. But for me, the biggest part of this case is the fact that we have somebody that is going through some real mental health issues, and it seems to be that she was failed every step of the way, all the way up through, the point where this interaction takes place and she ends up getting shot. It doesn't seem like it was taken into consideration by anybody, and they can't cry ignorance because everybody knew that she had been diagnosed with postpartum, which
Right.
is very real, and it's an actual thing. And again, this is one of those things where men that don't suffer from that because they don't give birth to babies, I think, may disregard it to the impact that it can have on a mother that's given birth. So to
Right. And
me, go ahead, man.
sorry. And Christina just says the fiance saying she was punching herself in the stomach. Was there other witnesses to that? Again, no evidence. Guys, you've got to remember in these emergency orders of protection, there isn't evidence. It's the words, whatever somebody says is what they consider. And it's the best of a bad scenario when you need to protect someone quickly, but that's why typically they're set very shortly thereafter to be heard in court where both sides get to do it and where evidence is expected. And if they can't put forth the evidence to back up those claims that they made, the order of protection doesn't get never turns into a permanent restraining order or order of protection. So yeah, there's no evidence to that at this point in time at
Yeah,
at
and
all.
I mean, these orders, when they're put into place, even on a temporary basis, you're in the cops system. Like that thing is a big deal. Like, is if anybody runs your name, even if it's a TRO, you're popping up as that there's a TRO against you. So I mean, they're very problematic in terms of employment, in terms of just moving about in a normal fashion. If you've got a cop behind you and they run your tags for whatever reason and your name comes up, they're going to see that you've got this TRO that, as Allison saying, is based on nothing more than the words of another party going in front of a judge saying whatever the hell they want unchallenged.
Right, and a
So it is
lot of
problematic.
people use it, like Bob said earlier, as a weapon in this day and age. They know that if they say the right thing, they get their husband out of the house right away. If they say the right thing, they'll have custody of the kids at least for longer. It's going to take a while to work out. I mean, there are obvious issues with it, but again, the courts have to have the ability, just on words alone, to do something immediately under an emergency situation, and then quickly get back and decide, is there actually evidence for this? Are we going to leave this in place? Is there more to it? Like we said here, we think they should have sent some sort of caseworker down to speak, to see the house, to speak to Kelsey and give an independent assessment as to whether this was, what is this you're going to next?
I didn't put that up.
Is Mandy doing this behind the scripts, the
Is
scenes?
Mandy back here? She must be.
Yeah.
So that's good. So it's good. That's Kelsey and obviously Justin, her, I'm assuming, former fiance at this point. They look like a sweet couple. You got a
Mandy,
couple of
you want to
first
hop on
responders.
here and say what it is you want to say about this? Or
There she is. She's
there she
hopping
is.
on. Wow, she's crushing it. There's some more tech wizardry. This time it's not me, it's Mandy.
I can't unmute her mic.
You cannot.
No,
Just because
she's
her
got to do it
mic's,
herself.
she doesn't have her mic on. That's why. Um, so wait, there is, we
She's trying
got,
to do something.
Stop yelling. I can hear you.
let's go, girl.
So are you putting this up for the picture, or there's some content in here you're
Yeah, I
trying
was
to?
just putting it up for the picture. I didn't realize that there were pop-ups. Sorry.
Oh,
No, that's
okay.
good.
Someone
That's
in
good.
chat asked for the photo of her and her fiance or whoever this is, so I just wanted to put it up there.
All right. Well, thanks
We
for that.
appreciate it. Thank
Bye,
you.
Mandy.
Hi.
Happy day after your birthday.
Happy day after your birthday day.
Thank you.
Happy birthday
Day
to you.
ya.
Happy
No, we're
birthday.
not doing it. It's so bad. The timing is so
I
terrible.
told him we should have called and sung to you
I
yesterday.
know. We should have.
All right. Happy
I
day
love
after your
you
birthday
guys.
day.
We love
too.
you. And we wish you the happiest of birthdays yesterday.
All right. So this is coming to us thanks to Young Jerks. It is the audio of I'll call it the bail modification request, asking to get rid of the breath test for alcohol. Because having been shot in the chest, it was very difficult for Kelsey to do this. It was causing great pain. It was inhibiting her recovery. And it did not seem that the pretrial services had any issue with this request or that the prosecution really had any issues with this request. But let's hear, how it went down, what the judge did. And thank you, Young Jerks, for allowing us to use this. It's only audio. So the Young Jerks has some pictures that are built into the background because all we have from that court is audio from any source as far as we can see.
Yeah, and if for whatever reason you're not subbed over to Mike over at Young Jerks, make sure you do that because we're always appreciative when other creators allow us to use their work. And Mike didn't hesitate. He said, absolutely, go ahead and use it.
So,
we
and then
appreciate
Randy,
that.
if we can put the link to them to encourage people to subscribe and check them out, that'd be great as well. All right.
All right, good afternoon. Calling come up first is Kelsey Fitzsimmons. This is docket number 2025-311 before the court in the defendant's motion. If the parties would please identify themselves for the record.
Good afternoon, James Cooper hosting on behalf of the Commonwealth.
Good afternoon. Good afternoon, Attorney Moore, you're able to come up.
You have it set up
Good afternoon, Your Honor. Mark Copley for the defendant, Kelsey Fitzsimmons.
way
Good
too
afternoon.
fast.
Hello, Your Honor, Timothy Grado.
What's wrong, babe?
It sounds like you have it 1.25 or 1.5. It's too fast.
Well, but it'll slow down. That's like the intro. So
Oh,
let's see if
okay.
you feel the same once they're arguing.
All right.
For Kelsey Fitzsimmons, she's present in the courtroom today for the record tonight.
Good afternoon, Mr. Good afternoon, everybody in the courtroom.
Thank you.
So I received the defendant's emergency motion for immediate release.
So everybody let me know if it's too fast. I guess they do kind of speak quickly, and I'll put it down to 1. I'll keep an eye on the chat.
Graham order. So I'll hear from the moving party.
Thank you so much, Your Honor. Judge, this is an issue that causes Ms. Fitzsimmons a lot of pain. And I don't want to conflate her being able to pass the test because she's been passing them. But she has about 4 hours of pain and dizziness afterwards. And I don't think anyone, and I know the court would share my thought that this shouldn't be a torture device for her. This shouldn't be something that causes her pain, impairs her rib healing, et cetera, et cetera. So, we're not trying to get any sort of advantage over anything. We just want her to not be in pain for hours after these tests, and B, we just want her to not have the anxiety that if she has a difficulty doing it, that she's going to get a knock on the door and get locked up. We were told by the Elmo people that, they may have to issue a warrant, and thankfully they didn't. And we appreciate, you have Mr. January's email regarding his own observations about what happened. And, I think that says it all. That's someone that has no bias or interest, and probation enforces court orders, and that's that. And he is telling the court this is a problem, and this is something that should be addressed. And
Okay.
so I see this as a simple adjustment of terms.
I don't see it that way. Just so you understand where I'm coming from, I don't see it that way.
Okay, can I?
Okay.
I don't understand what you're saying, Judge.
Okay, what I'm telling you, it's not a simple adjustment. One of the reasons she was released, and one of the reasons to ensure the safety of the community was for her to be alcohol-free. If she cannot do that or will not do that, that changes everything.
She's happy to be alcohol-free. She doesn't wish to be alcohol-free. It's just the means of determining that's the adjustment. That's what I mean when I say this is an adjustment that.
Well, a scram is what was ordered. Now, was she unable, when you said that there was a knock on the door, explain that to me. What
No,
happened?
Judge, that we don't want to have a knock on the door. She's living in fear of there being a knock on the door because of these tests. It's just not between the physical and then the mental anxiety. This is a very significant issue for her.
Okay.
And that, we just want to adjust whatever means the court wishes to test her or figure this out is fine with us. But this is just a very difficult environment. And just, that's something that I just want to ask the court to adjust somehow.
Okay, so you're asking the court to adjust the court's order that's been in effect for 3 days with no medical evidence to support your claim that she cannot do it.
Well, I think you have 2 affidavits and the email from probation. I think that's pretty persuasive evidence that this is extremely difficult.
The email from probation is not evidence. If you have any evidence, now is your opportunity to submit it.
I don't understand the court's position. That's not evidence.
Okay, it's an email. It's hearsay. Commonwealth, do you have a position as to the submissions of an email as evidence in this hearing to relieve the defendant, Ms. Fitzsimmons, of a condition that's been in effect for 3 days?
I don't want to put anybody on the spot, but we have the person who sent that email here.
Okay. So you have a burden. It's your motion. What do you want to do?
All right. So I'm just going to pause that for a second and chime in here. You now know as the lawyer that this judge is not seeing things the way you're seeing. She's giving you substantial pushback. The state just said the person who drafted that email is here. So you would expect that everything in that email would be now put in by oral testimony of this guy, and or that he confirms that that is his email. Everything in there is true and accurate. And then the email itself gets offered. Noteworthy is the fact that pre-trial hearings, hearsay is allowed. I don't know why the judge is saying that you can't have hearsay. You absolutely can have hearsay at a pretrial hearing. It depends what the hearsay is. This is something that is obviously reliable. It's a lawyer's putting it forward as an email that's coming from the probation department. She can see that it's coming from the probation department. To me, this was a non-issue, but also an issue that the lawyer had every ability to get around because the guy is in the courtroom. So you shouldn't need the email after these words are spoken, because you should get everything in that email testified to or introduce the email through his testimony. So let's go on and see what happens.
Well, Judge, I don't think that is the court saying that papers and emails and affidavits are not sufficient?
This is an email from a probation officer. The court gives that 0 weight.
Well, then you have an affidavit from Ms. Fitzsimmons and you have an affidavit from her mother
Call
of
the
the
guy.
physical observations of what happened. I think that's, the more persuasive evidence than a doctor saying something to the effect of, I think it's self-evident and it's common knowledge that if you have broken ribs, that it's hard to breathe.
What evidence do I have that she has current broken ribs and that she's suffering from broken ribs at this time?
Well, you have an affidavit from her mother. You have an affidavit from Ms. Fitzsimmons. And the other day we were here, I submitted I believe I submitted the instructions from Mass General about broken ribs.
Okay.
I mean, I would just argue that it's somewhat self-evident as well. Thank you. That it's somewhat self-evident as well. And that, she's having great difficulty here. It's been observed by probation.
So I'm just going to chime in again. At that point, I would have noted, I ask Your Honor to take judicial notice of the medical records that were tendered on this date, at this hearing, and see how the judge responds. I just would have, no matter how pro forma I thought it was, I would have had the, medical records there, and I would have tried to get at least an email or a letter or something from her doctor saying, that she has broken ribs, and as a result, this is, this is what she's claiming, and that's consistent with her injuries. I would have had something like that ready to go. I can understand in a case where the state doesn't seem to be fighting you, pretrial services is on your side. The only one that you're not anticipating, the judge on her own, is going to give you all of this pushback. But I don't know if efforts were made before this to get a letter from the doctor or something. He could have at least had those medical records that he mentioned he had he had tendered at a different hearing available for this hearing. So that's just me. Let me loop back one.
And that, she's having great difficulty here. It's been observed by probation. It's been attested to by her mother, and it's been attested to by Ms. Fitzsimmons. So it's just a very difficult scenario for her that luckily she has passed the test, but then she's got hours of pain afterwards. And the one that she had difficulty with, out of an abundance of caution, we were dealing with Elmo, and we were informed that they may issue a warrant. And
So I want to hear about the one she had difficulty with. When was that?
Wait a second.
So Sophia,
Well, so that's what I was saying. I don't want to.
Sophia says that this wasn't scheduled for that day. The judge, he filed it, and then the judge just called them in last minute. So that's why he wasn't prepared, and efforts were made. So thanks, Sophia.
Conflate passing with not having difficulty. She has difficulty with every single test. And so she passes them in great pain. So she's had difficulty in every single one, equated, it's in the affidavit. So she has difficulty on every single one. So that's different issue than passing the test. So she's experiencing difficulty all the way through. But the one that she was unable to, was 9/9/25 at 3:09 p.m., I guess.
And was that a required test that she was to do?
Yes.
And she was unable to perform it?
All right, guys, you're talking about the new filing that was done. And someone did send it to us. We have looked at it. We will put that up after we get through this stuff. Kyle sent it. Tracy got it over to us. So we are aware of it, and we will be touching on that. I kind of glanced at it.
Yeah, I've got them pulled up. And thank you, Kyle. Thank you, Tracy, for both of you guys forwarding this to us. There's a couple of different things. There's a plaintiff's verified motion for temporary orders. And then there's also the plaintiff's motion to attach real estate for the payment of child support. So we've got them, and we will go through them.
All right.
Correct.
Okay, that she was to do?
Yes.
And she was unable to perform it?
Correct.
Okay, was she unable to perform it?
No.
What happened?
No. So since she's been released,
Yes, swear in office.
Would
The
you raise your hand,
probation
please?
officer.
Do you solemnly swear you
All right. The person they're calling right now is the probation officer.
will make true answers to such questions that may be put to you by the court or upon its direction, so help you
I
God?
do. Or if I could just pass.
Pretrial
this
services.
Sure.
Information pertaining to all of her friends.
And is that being submitted, Attorney Braille, as an exhibit for the purposes of this hearing?
Judge, I'd be more than happy to do that.
It's not more than happy to. You're either doing it or not.
Yeah, sure. Go right ahead, Your Honor.
Okay,
It
so
just says that she passed the test, so which is not an issue. The issue is that she's in extreme pain while doing it.
And I think he kind of hemmed and hawed there about whether he was offering it as evidence, because, as the judge is about to get into, there are these incomplete tests that were then completed that she makes a huge issue out of, despite the fact that probation is adamant that that is not a failure. It's not something we would ever report. You're about to hear it all. So Here we go. Loop back one.
An issue. The issue is that she's in extreme pain while doing it. Whether she passes.
Okay, so there's one Officer January that says incomplete at 9/10/25 at 3:09 p.m. Is that right?
Yes, that's correct.
So what does that mean?
Yeah, so what it means is there's a scheduled test that's programmed daily for her to be alerted and to initiate a test. And that happens. And so initially she answers the alert and attempts to take the test, but is unable to complete the test. And based on my information, my conversations with Elmo is that is when she has difficulty either blowing as hard or as long, or a combination of both. into the machine to complete the test. So what happens after that is there are additional attempts to complete the test, which she tries, and then ultimately on that particular date, she successfully completes and passes the test on September 10th at 3:50 p.m.
Okay, what I have in front of me is an incomplete test at 9:10:25 at 3:09 p.m.
That's correct. And then if you just look
And then
right
it
above
says
that,
passed at 9:10:25 at 9:30 a.m.
okay, so you're looking, I'm referring to this second document, it's multiple pages.
I think if you just go up instead of the one above it, the
Okay.
incomplete is the.
So it's 3:09, it's incomplete, and then at 3:50 she passed.
That's correct.
So that's a period of 40 minutes?
That's correct. And you'll see the same thing.
So the other one, which is
September 9th, yes.
September 9th,
Again, at 3 o'clock.
but she
The test is initially incomplete.
at 3:09, and then it's complete at 4:21.
Yeah, 4:20, 4:21.
So there were 2 times that she had an incomplete test. Is that
Yes,
correct?
incomplete, and
And what's the procedure of the probation department when somebody who has a condition of release to have scram and to pass the scram test in a very serious case if they're incomplete? And I have 2 incomplete tests and I was not made aware of either one of them.
so my first job when we get an incomplete test is to gather more information. And so, which is what we do. And so in response to the incomplete test, we call Elmo, we gather the information, which is she answered the alert to take the test as scheduled. Unfortunately, she was unable to complete the test because she was unable to blow as long or as hard as needed to complete the test. So ultimately, at 4:20, she completes the scheduled test. There may be additional attempts in between, but ultimately she completes the test.
So that's for a period of
And so
an hour and 20 minutes.
that's correct. Now, in conjunction to the hour and 20 minutes, we also know that, and I observed it firsthand, that whatever the injuries are, which I don't know, and actually doesn't really matter to me, but when I was doing the installation process and observed what was genuine pain, like genuine pain. So I know.
Any objection to any of the terms used by the probation officer? Okay.
So
See, the judge is like, hey, can we object here that this guy's trying to say that he observed genuine pain and that he interpreted his pain? And the state's like, no, Your Honor, I have no objection to that. I mean, she keeps, you can tell with every question she asks where she was going on like, okay, and what does probation do in a very serious case like this when you have an incomplete test? There are 2 of them. I was not made aware of that. What does probation do in such a serious case like this? I mean, she's begging for the answers she wants and not getting them regardless. Loop back.
Any objection to any of the terms used by the probation officer? Okay.
So
No, Your Honor.
we have all that information. We don't deem that non-compliant. She's attempting to take the test and she ultimately passes the test at 4:20. So with all of the information, that's not non-compliant. That's compliance, and she, with her obstacles.
What do you, I'm getting confused. What do you mean compliant?
That's
As far as when she was initially,
That's compliant with scram testing. She was ordered
when she initially was, started to be monitored.
No, Your Honor. He's saying her ultimately completing it, the incomplete filed by the completion is compliant. Stop acting dense like you don't understand and trying to restructure what he's saying to mean, oh, wait, you mean she was compliant when you went out there to do the screening? No, that's not what he's saying. He's saying she is compliant. All of these are compliant. I don't see a violation here. All right, let's go.
It was ordered.
When she initially was, started to be monitored by Scram and you went through the preparations. Is that
Yeah,
right?
that's correct.
Okay. So when something is incomplete, do you typically bring it to the attention of the
No.
court?
No, that's not what we do. So if something is incomplete, as in this case, at 3, on September 9th, 3:09, we have an incomplete test, which is a scheduled test.
Mhm.
And then we have, that's simply not non-compliance. If she had missed the test, that would generate additional responses from LMO, and then that would determine whether or not there's actual non-compliance. If someone missed a test because they were down in the basement doing laundry and then came up and realized that they had a test, took an on-demand test 20 minutes later and passed the test, which means there's no alcohol in the system, we don't deem that as non-compliant. That's compliance.
That's compliance, Your Honor.
If they missed the test and additional notifications were made by the electronic monitoring office regarding the missed test, and she failed to respond or she failed to take an alert for another on-demand test, now that's non-compliance, and we would initiate a pretrial violation notice and notify the district attorney's office. This particular case, I don't deem non-compliance because she's complying with the scheduled program. I'm aware of pain based on my observations from the installation process. So as long as she's attempting to take the test, continues to attempt to take the test, and then ultimately takes the test, that's not non-compliance. That's someone that's,
Well, that's
to
your
me,
position that's non-compliant.
Well-
It's really up to the court to decide whether somebody's compliant or not with conditions of release. What you're saying
Wow.
is,
Right.
That's-
Wow.
Wow.
And he pushes back. He's like, but we would never report it to you. So you would never even get to consider this is whether or not
Right.
this is non-compliant. You'd never hear about it, Your Honor. I decide whether to report it to you. Under our protocols, this is not non-compliant. You'd never hear of it. You'd never know of it. You'd never be able to decide whether you think it's non-compliant, even though my department has not found it to be a violation. She gets worse.
Yeah,
worse.
I mean her bench demeanor sucks. Like
Yeah.
she's just not a pleasant judge to deal with in any capacity. I haven't seen her in any other cases, but just hearing her the first time we listened to this and now, not a fun judge to be in front of.
No. All right, let's continue.
conditions of release. What you're saying is, those situations you described is what you deem as appropriate to bring before the court.
it would, so I guess it would never be brought to court by way of a pretrial violation for an incomplete test with the information that I've talked about. So no, an incomplete test does not initiate a pretrial violation or from our end.
Right.
Because there are many reasons for a test to be incomplete. And there are circumstances where someone misses a test and then takes an on-demand test. That's not intentional non-compliance. And the goal is to test to ensure that the person's sober, and that's not, we don't deem that non-compliance. And we would never we never have, and
Gross.
we never would in this case, initiate a pretrial violation proceeding based on an incomplete test that was subsequently passed.
Key
And
word,
so,
subsequently passed, Your Honor. So you don't get to decide it because you would never
Right,
hear about it.
and clearly the probation
schedule
guy has the common
for
sense
her
to
to
know
be
that she
tested.
was shot in the chest. She underwent 7 surgeries. She was in the hospital for fucking 57 days and has
he
been out for
observed.
3. Right, when they were installing the fucking thing, she was in pain. So it's like there has to be a modicum of common sense, in terms of the evaluation as to whether or not she's trying to skirt the scram and sneak some booze. And in this particular situation, it's evident based on her physical limitations because of her injuries that that's clearly not what was going on here. And this judge is just fucking like obtuse. Like, why is she acting? Is she like it comes off as if she's pretending like this woman wasn't shot in the chest.
Right.
Like
Relying on
typically,
the fact that, well, I don't have any evidence right here, right now that she still has broken ribs.
oh my God. I mean, like I'm assuming the round somehow made its way to her lung.
Yeah, I think
Right?
we'll see that we'll see some more details in
I
the
mean, what the
motion
fuck?
to reconsider. All right, let's go.
The schedule for her to be tested is something that we discussed. Wasn't ordered by the court. The court ordered someone to be alcohol
What do
free.
you mean we discussed? So she knows
I
when she's going to be
discussed-
tested?
With Ms. Fitzsimmons, I discussed with the defense counsel about creating a testing schedule because it's more practical to have a schedule in place. There was no schedule that was ordered by the court. There's no
Oh, thank God. I don't know. Our internet went down bizarrely. I was like, what? What
All
happened?
right, sorry everybody. Sorry everybody. We're back. We're back.
Thank God Mandy was back there. That was
Yeah,
not
right.
our fault. That was our internet.
No, that was something weird with our internet. All right, so we're picking up to where the judge is going off on her next little hissy fit about whether it was supposed to be random and whether I don't know if you guys can hear me. I was trying to get Mandy to play this stream because we cannot get on the internet here. I don't know if Mandy is still even back here. Let me see if I can share. Let me see if I can pull up the audio from my phone and share it. Why is that not working? Sorry, guys. All right, so I can't share screen from here. Oh, yeah, guys. I don't know what to do. Mandy's supposed to be the lifesaver here. I don't know if she's back there. We share the screen. Yeah, I don't see how to do it. Play the sound we can hear. Oh, okay. Let me try that. All right, I'm going to play the sound from where we were while we try to figure this out. Oh, hold on. I got to switch it to my, I'm going to pull this out. All right.
We always do.
It was random screens that were ordered.
Mandy might be doing it. But that's not the right one. It's the 26 one without him talking. I've got the audio here if you want me to just click play, but it's a different feed. It's the one where you see the pictures like that we had up and it's 26 minutes. I can send you the link. There is an outage in our area. All right, I just sent the link to Mandy. We were at 7.
Afternoon, calling come up first is Kelsey Fitzsimmons. This is
We're
docket
at
number
17 minutes and 20 seconds.
2025-311 before the court and the defendant's motion. If the parties will please identify themselves for the record.
Afternoon, James Gubich.
There we go.
Created a schedule, as
With
we always
the-
do,
Okay.
as we always do, not in this particular case, we always do.
It was random screens that were ordered.
Judge, I don't have that. I don't have random screens anywhere in my materials for the record.
Okay.
I don't know nothing about random screens.
Okay.
Judge, just so I could clarify that. When we get an order, someone's placed on pretrial conditions that include remain alcohol-free with scram testing. We always default to creating a testing schedule,
Always.
and up to 4 times a day. So we'll schedule one for the morning, we'll schedule one for the mid-afternoon, we'll schedule one for the evening, and if we have to, we'll schedule one for later at night. And that's to ensure that sobriety throughout the day. In this particular case, we created a schedule for her to be tested at 9:30, 3 o'clock, and then at 8 o'clock. The only way we would not enter a schedule is if the court specifically said, I want the test to be done randomly. I don't want her to know when the test is coming. And the test to be done randomly. And at that point in time, we would take her off a schedule, and then we would notify Elmo to be tested 4 times a day at random.
Okay,
So that's done on this case, and it's done on every case.
okay. Attorney Bradle, do you have anything else to submit?
Judge, I would just offer, I respect and I heard your Honor's take on the probation email, but for the record, I would move that into evidence as well.
So Mandy, pause right here.
And I just want to also.
Commonwealth, do you have a position as to the admission of the email?
Well, I think we just heard what the
So right there, we already know that the judge didn't like the email. I don't know why Bradle did not ask, while the guy is right there to testify, what alternatives are available, and and how would they accomplish the goals, the pretrial goal of alcohol monitoring. And they could have talked about what other options were available. Why he's saying right now, I still want to get this email in, where she said, I'm not going to consider an email, when you have the very man who drafted the email there. And anything more you want to get out of him, AKA the available alternatives, he should have done right then and there with the actual person. So that was my issue with it. It looks like we might be able to get back in. So go ahead and click play while I see if
email.
All right, so the email is excluded. Anything else, Attorney
No,
Bradle?
my objection, Your Honor.
Sure.
And Judge, I just want to state that on the pretrial conditions of release, that says comply with remote alcohol breath testing.
Okay. I don't know if that's what was ordered. I'm going to go back and listen to FTR.
I can tell the court from where I sit, I didn't remember any use.
I mean, you may very well be right, but I'm going to go listen.
Judge, I just want to clarify something. My email, and I know but it's important that the court knows, I didn't make a recommendation that a scram condition be vacated. I never did that. I never suggested, it's all that email was.
Attorney, Officer January, nobody's asking you questions. Your testimony is complete. Are you asking to make a statement to the court?
Well, if the court's under the belief that I recommended that condition be vacated or removed, then yeah.
I haven't said anything one way or the other, sir. We're here for one purpose and one purpose
Okay.
only, and that's
Thank
for the motion to vacate the scram device. So do you have anything else to submit, Attorney Bradle?
No, Your Honor.
Okay, Commonwealth, do you have anything?
No, I have no evidence to submit other than the arguments that I talked about, how important that the Commonwealth's belief is. In light of the court releasing the defendant, that testing be done.
Okay. Attorney Bradle, here, first of all, I do have a question. So, Ms. Fitzsimmons is able to do the scram, is that correct? Or is she not able to do it? I don't know. Is she not able to do it?
That depends on whether the court is willing to tolerate that the material represented in the
The court
affidavit.
is not tolerating anything. Okay, let's be clear. I'm not tolerating anything. The court is not tolerating anything. Ms. Fitzsimmons is a defendant. In lieu of incarceration, my order was that she submit to scram. If she cannot do that, I need to know that. Can she do that or not?
She can do it.
Okay.
Under the terms that are laid out in the affidavit.
So you're saying she can do it on her own terms?
With significant pain and dizziness and having to recover for several hours.
I understand what you're saying. It is certainly not the court's intention. It's not the court's position to have Ms. Fitzsimmons in any pain at all. So I appreciate your argument. Do you have anything else to add?
I would suggest, Judge, that I think there's other ways to do this. If the court wishes to have her tested for alcohol compliance, lack of alcohol, that's completely fine with the defense, but just the means that's being employed is kind of a torture device for her.
Okay.
So
And
suggest
we
other
object on
means.
due process grounds to that.
Oh, okay.
Suggest
But
other means.
It is not this court's intention
I understand.
to torture Ms. Fitzsimmons at all. The court's goal is to make sure the community is safe and Officer Noonan is safe. So I hear you loud and clear.
So when Bob and I were listening to this the first time, I'm like, this guy is like giving the judge every reason to be like, all right, you just said she can't do it and that it's cruel and unusual punishment if she does it. So that's it, back in jail. Like, it's like you have to read your audience. And I'm not like taking up for the judge what she's doing, but I'm just wondering that the lawyer isn't seeing the writing on the wall and didn't take the time. He just said the words, I think there are other alternatives. Damn it, lawyer. Give her those alternatives.
I know Bradle's a good lawyer from everything I've seen. It just seemed like, because as we were saying, and you and I were having a discussion off air when we were first listening to this a couple of days ago, I'd be calling probation to find out, well, is there an alternative to the blow test?
He's right there.
I know. It's like,
And
is there not
keep
any kind of
telling me
alternative?
that the alternatives were in the email, if the alternatives were in the email, why in the hell didn't he get it out while the guy's standing there?
Yeah, because hearsay is allowed in motions. The rules of evidence are relaxed in motion hearings. Like, he would have been able to get the email in, even though the judge said it was hearsay.
She said, no, I'm not considering it. She was
What?
wrong on the law. She said, no, an email's hearsay, and I'm not considering it at this hearing.
Wow, that's fucked up. I mean,
and we'll talk about that again when we talk about the motion to reconsider that was filed and the judge's answer on that. I can understand that he's completely shocked at her position. He doesn't understand why but I'm just saying the writing was starting to get.
That the defense views Ms. Fitzsimmons having to do the scram as cruel and unusual and torture. Is that your position?
Well, that's an Eighth Amendment position. I suppose that can be put in there as well. But Judge, I think that, there's probably other alternatives that she could do that I believe are out there. But I know that might step on the court's other order for house arrest, that you would have to go to a facility. I know there's like urine tests and other things like that. So I know there's other possibilities out there that, again, she's not trying to use this to create a situation where she can go drink alcohol. That's not at all what this is about. So I just want to ask the court to consider any other alternatives that might not pose this type of an issue.
Okay.
Thank you.
Attorney Gubitosi or Attorney Moriarty, do you have anything to add?
No.
Okay, I'm going to leave the bench for a few minutes. I'll break.
Court, all rise.
Your Honor, we're back on the record with the Fitzsimmons matter.
Okay, good afternoon, everybody. So I have reviewed everything again that's been submitted to me. And I will state for the record that Fitzsimmons has moved twice in a 3-day period to amend her conditions of release. On neither occasion has she submitted any medical evidence to support her claims. The imposition of conditions is the court's order after careful consideration of the evidence to fashion the least restrictive conditions that will reasonably assure the appearance of the defendant and the safety of all other persons in the community pursuant to General Laws, Chapter 276, Section 58A2B. Just days ago, the court concluded that the condition of remaining alcohol-free and submitting to SCRAM monitoring was necessary to ensure the safety of the community. After a thorough review of all of the arguments and
Good. Keep playing, Mandy, unless it is, and I just don't know it.
submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged, regardless of Fitzsimmons' claimed physical limitations. Based on an affidavit submitted by Fitzsimmons' mother, the testimony of Assistant Chief Probation Officer Jeff January about his observations of Fitzsimmons' apparent pain during the SCRAM installation, and the representations of Fitzsimmons' counsel that it would be cruel and unusual punishment and torture to continue to require Fitzsimmons to comply with the condition of being monitored by SCRAM. The court concludes that Fitzsimmons cannot abide by the condition of being monitored by SCRAM. Without this condition, which ensures that she does not consume any alcohol, the court cannot assure the safety of Officer Noonan and all other persons in the community. Accordingly, the court's prior order of release is vacated, and Fitzsimmons is ordered to be held without bail pursuant to Mass General Laws, Chapter 276, Section 58A. And a written order will
May I
follow.
address the question?
That's the court's order. Thank you.
All right. Your Honor, I object. I ask you to stay your order pending the SJC. And there are other alternatives Your Honor can accomplish.
So you can hear Kelsey crying in there. You can hear how shocked Bradel is. I mean, this was a complete outrage as far as I'm concerned. I'm just, all I was pointing out is that the writing seemed to be on the wall, and I think that Bradel should have taken the time to put the other alternatives in front of her by way of testimony from probation as to what would the alternative be to this. Now, one thing Bob and I can't understand is if they're using SCRAM, they could have gone to SCRAM and said, all right, let's use a ankle brace for this. So the one that we said before, it goes through the skin contact and can continuously tests throughout the day for any alcohol in the body through the skin. Maybe that isn't an option there. But if they're using SCRAM, it should have been. Alternatives such as leaving, that should not concern the judge if she's on GPS and she is leaving to go report to pretrial services. That is a non-issue. That is a non-issue for the judge as far as, oh no, she's on house arrest, I don't want her to leave. No, going from your house to pretrial services is not a thing that the judge needs to be concerned about. I don't know how to continue with the rest of this. We obviously have more lined up. Back to not being able to get onto StreamYard. This is so frustrating. I could send the documents to Mandy, but this is what I was suggesting to you guys earlier. Do you take this as a judge who's trying to go over the top because it's a cop and she doesn't want to be seen, giving preferential treatment to a cop? To me, it seems like more than that here. It really does. I mean, you've got her not understanding how probation works, her misinterpreting the results, the incomplete, and how she should perceive that. It just seemed over the top, just over the top. Guys, I don't know what to do here. I don't know what to do. Still not able to get on my computer. Mandy, I don't even know if you have, like, did I send to you? Let's see if I can insert some files here. All right, I'm going to send these to the motion to reconsider and supplement the motion to reconsider to Mandy so she can put it up. Let's see. And then the judge's order. So the defense filed a motion to reconsider after this, and that's what I'm hoping Mandy can pull up. And if you guys can hear me, I can read. Otherwise, Mandy, you can hop on and read. Bob's like, am I the only one not on? No, we're all having this issue. I appreciate that many of you have stuck around despite this this issue. And I can't see backstage, but I'm assuming Mandy is still back here because she had just had up the stream. All right, you guys can hear me. All right, let me well, I'm seeing if Mandy can share the documents for the motion to reconsider. I'll look at some of your guys' comments. You know, we could do that. Maybe we save this and we do part 2 of this stream when the internet is fixed and we pause here. I think that is what we should do. And we will be back. Let me just go tell Bob that that's the plan. I don't know if he's like out there trying to rewire the shit himself. I'm gonna go out there and do it. Babe? So I'm saying that we're gonna end the stream and then we will restart part 2 when the internet's up. I'm saying that we're gonna end the stream and then we will. All right, guys, that's what we're gonna do. We'll end the stream here and we will do part 2 as soon as our internet issues are fixed. Thanks for hanging in there with us. And we'll see you soon. Bye.